Okay, let's unpack this. Imagine a set of rules, like really fundamental rules, that dictate how human beings treat each other during war, even enemies. And this isn't just some high-level international idea. It's actual law woven right into a country's own legal system. Today, we're taking a deep dive into exactly that, South Africa's implementation of the Geneva Conventions Act 8 of 2012.
We are indeed. This act, it officially started on December 1st, 2012. And our mission today is really to get under the skin of it. We want to understand its purpose. Yeah. What are its key parts? How does it fit into South African law? And what does it actually mean, in the real world? For law students, sure, but for everyone. We'll be looking directly at the act itself and pulling in bits from the actual Geneva Conventions and their protocols, trying to make this whole area of international humanitarian law a bit more accessible.
Great. So let's start with the big picture then. Why? Why did South Africa need this specific law? What was the real push to bring these international agreements into domestic law?
Right. Well, the Act itself lays out three core objectives right there in Section 2. First, it's to formally enact the conventions into law. And that's not just a nice to have. It's actually a constitutional requirement. Section 2 of South Africa's constitution demands it. So step one, make these international rules legally binding at home.
Okay, so it's constitutionally mandated?
Exactly. Second, it's designed to ensure that the Republic complies with the conventions, basically making sure South Africa lives up to its promises on the international stage. And third, and this is crucial, it aims to ensure prevention of and punishment for breaches of the conventions. This isn't just theory. It's about having mechanisms for enforcement, accountability.
That link to the Constitution, that feels really important. It's not just signing a treaty, it's embedding it. Does that make it, stronger somehow compared to countries where it might stay more external?
You've hit on a key point there. Yeah, I think it does. When it's constitutionally required and directly written into national law, it gets, real legal teeth domestically. South African courts aren't just thinking about an international agreement. They're applying South African law that includes those obligations. It boosts enforceability, gives clear rules for the military, for civilians, and it signals a serious national commitment. Plus, Section 3 says courts dealing with this act have to look wider.
Wider how?
They have to consider and can apply other key legal sources, like conventional international law, so treaties, and customary international law, those long-standing global practices everyone accepts as law. They could even look at how other countries handle similar things, comparable foreign law.
Wow. Okay, so it really pushes for a holistic, globally informed approach to justice in these cases, which makes sense given the international nature of these rules.
Precisely. It ensures the spirit of international law is applied consistently within the national system.
Okay, that framework is super interesting. Now let's get into the specifics. Where does it get really interesting, I guess? What actually counts as breaking these rules under the Act? And what happens to people who do?
Right. This is where the Act gets very specific. It makes a really important distinction between what it calls grave breaches and other kinds of breaches. Grave breaches, as the name suggests, are the most serious violations. And crucially, Section 5 says they are crimes whether they happen inside South Africa or outside.
So that's that universal reach kicking in already.
Exactly, for those grave breaches. We're talking about things like willful killing, torture, or inhuman treatment, and that explicitly includes biological experiments. It also covers willfully causing great suffering or serious injury, or massive destruction and theft of property that isn't militarily necessary and is done, unlawfully and wantonly.
Horrific stuff. What else falls under grave?
Forcing a prisoner of war or a protected civilian to fight for the enemy. Deliberately denying them a fair trial. Unlawful deportation, transfer or confinement of protected people. Taking hostages. That's from the Fourth Convention and Protocol 1. And Protocol adds more, like launching indiscriminate attacks expected to cause excessive civilian casualties or damage. Or attacking dams or nuclear plants knowing the potential danger.
Okay, so attacking critical infrastructure like that.
Yes, if it contains dangerous forces. Also, making undefended towns or demilitarized zones the target of attack. Targeting someone who is hors de combat, wounded, surrendered, out of the fight. And a really specific one, the perfidious use of emblems like the Red Cross. Using them deceitfully to gain advantage.
And you mentioned protocol. I also include something very resonant for South Africa.
Yes, absolutely. Protocol and explicitly lists practices of apartheid and other inhuman and degrading practices based on racial discrimination as grave breaches when committed during armed conflict or occupation. Given South Africa's history, its inclusion is incredibly significant. It reflects a global consensus that such state-sponsored discrimination, when rising to the level of inhuman acts in conflict, is a violation of fundamental humanity.
A powerful statement embedded in this law. So those are the grave breaches. What about the other breaches you mentioned?
So Section 5 also covers other breaches. These are still serious violations of the conventions that happen within South Africa or are committed by a South African citizen outside the country, but they don't meet the high threshold of a grave breach. But don't mistake other for minor. For any offense under this act, grave or otherwise, the penalties are severe. A person can face a hefty fine, imprisonment, including imprisonment for life, or potentially both.
Life imprisonment. Wow. Okay, that certainly underlines the seriousness. Now, it's often not just the soldier on the ground, is it? What about commanders, leaders, people higher up?
That's a vital part of this. Section 6 deals directly with failure to prevent breaches of conventions, command responsibility. Basically, a military superior officer is guilty if forces under their effective command commit a breach, and that officer knew, or importantly, reasonably ought to have known, that the forces were committing or about to commit such acts and failed to take all necessary measures to prevent or stop them.
Reasonably ought to have known, so ignorance isn't necessarily a defense?
Not if they should have known, given their position and the circumstances. This duty also applies to any person who fails to act when they have a duty to prevent such breaches. And military superior officer is defined broadly. It includes anyone acting as such or even a civilian in a superior position relative to those forces. The penalties, just as severe as for committing the act directly.
That's incredibly important. Accountability all the way up the chain. It puts a real onus on leaders.
So we've mentioned acts happening outside South Africa.
Yeah.
How does the law actually give South African courts the power to prosecute those? Okay, so this comes down to Section 7, and it uses that powerful principle of universal jurisdiction for these specific offenses. Section 7.1 essentially says any court in South Africa with criminal jurisdiction can try someone for an offense under this act, as if the offense had been committed in the area of jurisdiction of that court, notwithstanding that the act or omission was committed outside the Republic.
So it doesn't matter where in the world it happened. If the person is brought before a South African court, they can be tried under this act.
That's the principle for these specific convention breaches covered by the act. The Minister of Justice then designates the specific court that will handle the trial. It's a major statement about these crimes being an affront to everyone.
A critical detail, especially for anyone studying international law. But what about the accused? If someone is facing these serious charges, possibly far from home, what protections does the act guarantee them? It can't just be prosecution without safeguards.
Absolutely not. The act mirrors the conventions themselves in providing significant safeguards, particularly for what are called protected persons, like prisoners of war or civilian internees. For example, Section 9 requires that if a protected prisoner of war goes on trial, the court must inform the protecting power.
Protecting power, what's that?
It's usually a neutral country that's agreed to look after the interests of prisoners from a specific side. Their job is to ensure humane treatment according to the conventions. The court also has to notify the prisoner's official representative. It ensures international oversight.
Okay, so there's a sort of external check built in. What about lawyers?
Section 10 guarantees the right to legal representation. They can choose their own lawyer if they can afford it, or have one assigned at state expense. And interestingly, if they don't choose, a lawyer instructed by that protecting power can step in to represent them.
And appeals.
Yes. Section 11 gives protected persons convicted of serious offenses things carrying 2 years or more extra time to appeal. Up to 10 days after the protecting power has been officially told about the conviction and sentence. Again, it emphasizes that international awareness aspect. And one more thing, if there's ever doubt about whether someone is protected prisoner of war or internee, Section 8 allows the prosecution to ask the court for a formal ruling on their status.
It really paints a picture of trying to balance the need for justice against these terrible crimes with really fundamental humanitarian protections and due process.
That's the core idea, yes.
Yeah.
Maintaining standards even in the worst situations.
Now, shifting gears slightly, when we think about aid workers or medical staff in conflict zones, certain symbols immediately come to mind. The Red Cross is probably the most famous. How does this act protect those vital emblems?
Ah, yes, the symbols. Chapter 5 of the Act is dedicated to this. Section 14 gives very strong protection to a whole list of flags, emblems, signs, signals, even specific wordings in ID cards. This obviously includes the Red Cross on a white background, the Red Crescent, and also the less common Red Lion and Sun emblem. It even protects the Swiss flag, the white cross on a red background because of its historical connection.
Why protect the Swiss flag?
It's the reverse of the Red Cross emblem, adopted out of respect for Switzerland where the first Geneva Convention was signed. So the Act protects that too. And the rule is strict. No one can use or display any of these protected symbols without written permission from the minister. And that permission is only given for purposes related to the Act, the South African Red Cross Society's own work, or the conventions themselves.
So you can't just stick a red cross on your private ambulance for no reason.
Absolutely not. And Section 15 makes the penalty clear. Misuse can lead to a fine or imprisonment up to 5 years, or both. This responsibility even extends to companies. If a company misuses an emblem, the directors or managers can be held liable if they knew about it or could reasonably have prevented it.
5 years just for misusing a symbol. That shows how seriously they take it. And it's not just the big international symbols, right? What about South Africa's own forces?
Correct. Section 17 is quite specific. It says that military medical personnel and chaplains within the South African National Defense Force must wear armlets and carry ID cards that clearly display the Red Cross emblem. This makes their protected status instantly recognizable in a conflict situation. The minister can even ask the SA Red Cross Society to supply extra medical teams, and if they do, those teams also get to display the Red Cross protectively while operating under military law.
It really highlights their practical function, doesn't it? These aren't just logos, they're shields. They're legally recognized markers meant to ensure safety and allow humanitarian work in the middle of chaos.
Precisely. They signify neutrality and protection under international law.
Okay, we've really dug into the Act itself. Let's zoom out a bit now and touch on the actual Geneva Conventions that this Act brings into law. Who exactly are they protecting, and what are some of the core protections?
Good idea. The Act, as we said, implements 4 main Geneva Conventions and their 2 main additional protocols. Each focuses on different groups. So Geneva Convention, that's for the wounded and sick and armed forces in the field. On land, basically. It demands humane treatment, proper care, and strictly forbids any discrimination, treating people differently based on race, religion, etc. It protects medical units, hospitals, and staff like doctors, nurses, chaplains. It even allows for setting up special hospital zones.
Okay, so land warfare, wounded, what's next?
Geneva Convention 2 does the same, but for the wounded, sick, and shipwrecked at sea. It extends those protections to naval warfare, specifically protecting hospital ships and their crews.
Makes sense. Then the famous one.
Right. Geneva Convention III, Treatment of Prisoners of War, or POWs. This is huge. It defines who qualifies as a POW, typically members of armed forces, militias, even civilians who spontaneously take up arms if they meet certain conditions, like carrying arms openly. It sets out their rights. Humane treatment, respect for their person and honor, adequate food, shelter, clothing, medical care. They have rights to send and receive mail, and crucially, the right to fair trial procedures if accused of crimes. They can't be tortured for information beyond basic ID.
And what about civilians caught up in it all?
That's Geneva Convention V, Protection of Civilian Persons in Time of War. It defines protected persons generally as civilians who find themselves in the hands of an enemy power or an occupied territory. It prohibits violence against them, torture, collective punishments, punishing a whole group for one person's actions, pillage, reprisals, taking hostages. It sets out special protections for children, pregnant women, and ensures access for relief organizations.
So those are the original 4. What about the protocols?
The additional protocols from 1977 significantly update and expand these protections. Protocols deals with international armed conflicts. It broadens the definition of wounded, sick, shipwrecked to cover civilians too. It lays down detailed rules protecting the general civilian population and civilian objects, prohibiting attacks on purely civilian targets, indiscriminate attacks, and those attacks on dams or nuclear plants we mentioned. It also boosts protections for civil defense workers, women, children, and even gives journalists on dangerous missions civilian status.
And Protocol 2?
Protocol 2 is incredibly important because it addresses non-international armed conflicts. Civil wars, basically. Conflicts between a state's armed forces and organized armed groups within that state. Even in these internal conflicts, it sets minimum standards. It demands humane treatment for all non-combatants, banning things like murder, torture, rape, slavery, collective punishments. It provides basic guarantees for people detained, including fair trial standards, and protects medical staff and facilities.
It really seems like they tried to cover almost every angle, didn't they? From who counts as a soldier to how you treat a captured enemy to protecting hospitals, civilians, even in a civil war context.
It's an incredibly comprehensive body of law built up over time, trying to inject a minimum standard of humanity into the brutality of armed conflict, covering combatants, non-combatants, places, objects, even cultural property get specific protection.
Okay, connecting all these dots then, how does this South African Act fit within the broader international legal picture? Does it overlap or interact with other major laws? And maybe a key takeaway for people listening.
Yeah, a very significant point is in Section 20 of the Act. It explicitly says that this Act does not limit, amend, repeal, or alter South Africa's other major piece of international criminal law legislation, the implementation of the Rome Statute of the International Criminal Court Act, 2002.
Ah, the ICC Act, so they work together.
Exactly. They're complementary. South Africa's obligations under the Geneva Conventions through this act and under the Rome Statute, which deals with genocide, crimes against humanity, war crimes more broadly, and aggression, exist side by side. They reinforce each other. It creates a stronger net for accountability, offering different, overlapping legal routes to justice.
That's a really important clarification. So multiple layers of law working towards similar goals. Anything else people should really take away?
One thing that's often missed, but is actually written into the conventions themselves, and thus part of what this act supports, is the obligation of dissemination. Articles in the conventions and protocols explicitly require states to spread knowledge of these laws as widely as possible. They need to include them in military training, yes, but also encourage study by the civilian population.
So it's not just for lawyers and soldiers.
Not at all. The idea is prevention through education. If people, soldiers and civilians alike, know the rules, know their rights and obligations, they are hopefully more likely to respect them and more empowered to demand compliance. It's fundamental.
That really drives home the point that understanding these laws isn't just an academic exercise. It has real-world importance for everyone, particularly in regions affected by conflict.
Absolutely. Knowledge is a key part of making these laws effective.
So we've taken quite a journey today through South Africa's implementation of the Geneva Conventions Act of 2012. We've seen its core aim, bringing international humanitarian law right into the domestic system. We've looked at how it defines and punishes grave breaches, holding individuals and even commanders responsible. We've explored the web of protections for combatants, civilians, medics, even the symbols like the Red Cross, all grounded in the Geneva Conventions and now firmly part of South African law.
Yeah, I think this deep dive really highlights the Act's commitment to human dignity, even in the darkest times. It shows a dedication to fair trials, and crucially, it gives South African courts that powerful tool of universal jurisdiction for these serious crimes, no matter where they occur. It's a legal embodiment of fundamental humanitarian principles.
So what does this all mean for you, our listener? When you think about the incredible detail, the high ideals, the universal reach of the Geneva Conventions and protocols that this act implements, what do you think are the biggest ongoing challenges for states and for individuals in actually making sure these humanitarian laws are followed in today's complex, messy, modern conflicts? Something to think about until our next deep dive.